I'm back, y'all. I gotta revisit trade name registrations. Also known in some states as fictitious name registration or assumed name, as you see right here. This is Virginia. I'm doing Virginia today, y'all. Virginia and Nebraska, because I've talked to two people, both of them, each one of them lived in, in these states right here, and I was talking about the same thing. One of the guys actually brought a suit in federal court, trying to sue somebody in federal court. I don't know if he did it before or after, but anyway, bottom line is, I don't want to use this situation because I don't know the order when he did his. But I know a lot of people, when they go to federal court, they never get no remedy there. They get their cases thrown out, most of the time. Now, I want to touch on. I want to kind of give a little context about what I'm talking about when it comes to trade name registration, because as I said in previous videos, I'm not sure. I was saying I'm not sure if me registering a trade name was the main reason why I beat my case or not, or was it simply because I just chose to buck and I kept objecting and I never would comply. Though I do know that me standing on what I just said, me filing an objection into the court case and never giving any check stubs, never giving anything, I just kept rebutting everything they kept sending me. I kept doing that. But the thing is, it started in September 2016 and it kept going until like June, July, something like that of 2017. That's a long ass time to keep going back and forth with a paperwork, even after you filed your objection, even after you continuously kept filing objection and kept not consenting and going through all this back and forth with these people, month after month, week after week. It was exhausting, and it wasn't until I did the trade name registration properly, because I did it once before. I think maybe in January, or I think it was January of 2017, but I didn't do it properly. I put on there that L. McHale. I was on that more shit. L. McHale. I made up a name. Just made up a name for myself, saying L. McHale is the beneficiary, grantor beneficiary of, the Michael Eugene Roseman estate, something like that. And I put all that in the newspaper and everything. I went through the whole process, but I used the wrong name. I didn't use the name that my father and mother gave me, which is the real name that actually, the given name that my father and mother, that actually really does have an interest in that estate. I can't make up a name and say that name has interest of an estate that nobody's ever heard of. It's something I just conjured up out my own head. And I was wondering why the railroad kept going. It kept on going. And so though I was bucking and they couldn't get me in a court, they couldn't write up an order that was locking me into a child support obligations. But they kept trying and it was stressful because of the fact that it was my first rodeo show and I was learning as I was going. So it was extremely exhausting. It was hard to get those people to leave me the fuck alone. Okay? So, but when I went and did it properly, I might have did it maybe in April or May, did it properly. And that's when eventually at some point, it wasn't, of course I started filing it. I don't know when I actually filed it in the court case, but that's when I actually started trying to go back and do it properly. And I don't know when I did it on two different occasions. One is an amended version. Matter of fact, I think the amended version was the correct version. And when I did the amended version, it was the correct way of doing it. And I don't know when I actually finished it. And when I finished it, I went ahead and filed it into the court case. And I think they might have made one more attempt after that. And after that, they just stopped filing every damn thing in the damn court. They stopped bothering me by June. June or July, they stopped bothering me. I want to say June, but I'm not sure. It could be July. But keep in mind, and it wasn't like they were sending me stuff every single week. It's just that time just kept on going by and they were trying to think of stuff. And then when I finally filed that stuff, I got it created and I recorded in the county recorder's office. And then I finally got it into the court case. Keep in mind, when I filed it in the court case, I didn't file it with a motion to dismiss or nothing. I just filed it in the damn court case. And so I didn't even file it properly. So it's probably why they still was trying some shit in the first place, even after that. But After I guess the smoke pretty much stopped once I got that done. Once I got it done, and they stopped bothering me altogether. And it was maybe about a year or so when they finally just shut the case down, because there wasn't nobody filing nothing in there, and they wasn't filing nothing in there for me, and I wasn't filing nothing in there for them. By that time, I opened up my own court case and was pursuing my son's mom in a separate court case. So at some point, they kind of merged them together or whatever. But anyway, that's whatever. Bottom line is, the trade name registration, I'm gonna show y'all exactly what it says about when you choose not to do a trade name registration, and you choose to dismiss it. A lot of people have slept on this process that is very needed. You need to do this. Even if you don't have a court case going on, if you're doing business with that name, you need to have that name registered. Now, I'm going to read this. Here we go. Trade name. Do I need to start here? Let me see if I can back up first. See what it says. Conspiracy. No, not there. Remedies violation. Authority general action damages. No, I'm gonna go back to where I was. Get back over here. Okay. As used in this chapter, unless the context requires different things, commission means the state corporation commission. Now, keep in mind, this is Virginia. Your state may say something different. You definitely want to look into your state, and all these states have their own processes. This is why I don't advocate for the assumed name certificate no more of Minnesota, because every state have their own. Keep in mind, every state is like their own country. They're their own separate jurisdictions. You're not. That's why that process was hit and miss, and a lot of people wasn't getting a lot of remedy from that shit, because everybody jumped on the bandwagon, grabbing it, including myself. I even got one. I might have did maybe 3 or 4 of them damn things. And the thing is, they're hit and miss. Some people got remedy from it, but not enough people getting remedy from it for me to continue advocating for it, because it's not a kill shot. So I stopped endorsing it. So therefore, I really advise people to look inside your state codes and see exactly what it says, the process on what they have set up for you to actually create, to register the name that you're doing business with, that being the straw man, or any name you're doing business with. Okay, person has the meaning prescribed in 1-230. I'm gonna see what they're saying right there. Person, according to these codes, person includes an individual, corporation, partnership, association, corporative, limited liability company, the LLC, a trust. Even if you're doing a trust in Virginia, you need to be registered in that thing. So if you're gonna do business with it, then you might want to do a registration for it. Okay, joint venture, government, political subdivision, or any other legal or commercial entity. That's your straw man. Okay, and any successor, representative, agent, agency, or instrumentality thereof. Okay. So now they're telling you what a person is. Now, back up. Here we go. No person shall conduct or transact business in the Commonwealth under any assumed or fictitious name unless such person files in the office of the clerk of the commission a certificate of assumed or fictitious name. No person shall use an assumed or fictitious name in the conduct of the person's business to intentionally misrepresent the geographic origin or location of the person. Okay, filing a certificate right here. It's telling you about the fee. Certificate or assumed name, fictitious name shall be in the form prescribed by the commission that's set forth in the following. It's telling you how it needs to be done. Okay, these codes tell you how to play the damn game. You got to learn how to play the game in your state. Because you're gonna have to be playing it by default. You're gonna get railroaded. You're gonna learn the damn game. Okay, let's see. Print out the name, title. This is once you finish all that. Let me see. Certificate of release. Say when a person who no longer conducts business at okay, that's when that's when you're done with it. When you're done conducting business. Let's see. Recordation of certificate. Let's see. The clerk of the court with whom a certificate of assumed name or fictitious name is filed shall keep a book in which all certificates of assumed or fictitious name and certificates of release of an assumed or fictitious name are recorded with their date of record, and shall keep a register in which shall be entered in alphabetical order the name under which every business is conducted, and the names of every person owning the business. No license shall be issued by a commissioner of the venue until the certificate assumed or fictitious name has been made and filed in the clerk of court of the commission, or prior to January 1st, 2020, in the office of the clerk of court, and evidence of the filing have been provided to the commissioner of the venue by the person conducting business under the assumed or fictitious name. So they got to record it in Virginia. Okay, they got to record it. I don't know, my buddy Mike, you know who you are. If you're watching this video, you know you got to record that damn thing. If you did it, I hope you recorded it, because it says you need to be recording it. Okay, so you can go look that up yourself. Virginia 59.1-74. You'll see it yourself. I ain't gonna say your last name. You know who you are. Any person violating any of the provisions of this chapter shall be guilty of a misdemeanor, and upon conviction shall be punished by a fine not exceeding $2,500, or by confinement in jail for not more than 1 year or both. Okay, penalty for signing false certificate. Okay, you know they tell you about the penalty. This is what I want to read too. A failure of any person or corporation to comply with the provision of this chapter shall not prevent a recovery by or against such person or corporation in any of the courts of the Commonwealth on any cause of action heretofore or hereafter arising, but no action shall be maintained in any court in this Commonwealth by any such person, corporation, or his or its assignee or successor in title, unless and until the certificate required by this chapter has been filed. You can't sue no damn body till you do this. If you're trying to sue somebody, trying to bring them to court, federal court, whatever court, it's saying any action, any cause of action. You can't maintain. You have no standing if you don't do this. If you don't do a trade name registration of that fictitious name, whatever name you're doing business with, if you in court and you trying to get all child support and you trying to have some standing up in there, you better be trying to do this. Okay? You have no standing if you don't do it. It's telling you this. It's what they're telling you. Emeralds didn't tell you this. I told y'all this in 2019. A lot of people sleep on this. I did this myself. I wonder why they kept railroading me. And when I finally did that shit, and when I filed it properly, I probably didn't file the shit properly in the court case at first, but I did this shit for the process properly. But did I file it in the court case properly? I don't even know. I ain't even go back in there. As long as the smoke is cleared, I'm good. So bottom line is, I did do this properly. I went and did this according to my state statute, which is in Georgia, and I did it properly, and I beat the damn case. Now, if you're trying to beat your case and you're trying to get out child support, you better have some standing first. Okay? So I thought I had to start off with Virginia, because that's my partner who I talked to yesterday. He corrected me also, because I was telling him he did do the trade and he did do the registration. I don't know if he recorded it though. If he didn't record it, you need to record it in the county recorder's office, because it told you got to record it. It specifically said you got to record it. Where does it say that? It says it got to be recorded. Let's see. In the clerk of court, the office of the clerk of the court, the clerk of the commission. And you go back to where it says the definitions, it tells you what commission is. Okay, commission. That's the state corporation commission. Whatever that is, I don't know where that is, Mike. You know who you are. Wherever that is, you better go record that there. If you did that, then you good. But bottom line is, and oh yeah, Mike, he schooled me on something, because he was telling me he got a certified copy of this that he did, and I was saying that I was spewing him down saying, no, they emailed you something. They wasn't no damn certified copy if they emailed it to you. And you say, yes, it did. That's what they told me. They do it different here in Virginia. And I'm like, nah, that lady lied to you, man, because ain't nowhere in the hell she sent you a wedding copy, a wedding signature on a document if it was emailed to you. And then I went into the state statutes, and I'm not gonna look for it in here because that's not relevant to this, right? What I'm trying to show for this, it's not relevant to this video. But he showed, as I read in the state statutes that, in there. Matter of fact, I might have it pulled up. No, I don't have it pulled up. But because I have to type his name up, and I don't want to type his name up, putting him out there on blast, because that's the only way I can find it right away. But anyway, the thing was, he showed, it showed me on their website where, in order to get a certified copy, you pay a $6 fee, and they'll email it to you. And I'm like, oh shit, okay, well I stand corrected, and I don't have no problem being proved wrong. If I'm wrong about something, fuck it, I'm wrong, and I don't mind being corrected. So he did correct me. That was in a private conversation. So now I do know that some states will, the way they have it a way where they can give you a certified copy of a record, and it's emailed to you, and it's not a wet ink signature and an embossed stamp. It don't have to be that. Here in Georgia, that's what it is. But Virginia is an exception to the rule when it comes to this. Now I want to go to Nebraska. I talked to a partner in Nebraska. And I'm gonna show you what his state statutes say the exact same thing. Let's see where we at. Trade name. Is this what I want to go to? Let's see, within 60. No, this might be it. Let me see. Let me duplicate. Enforcement of rights. Injury. I want to start with the beginning. See it in the suit. Am I right? Misuse. Cancel. See it. Damn, I was already on it. I probably messed it up. I don't need this one right here. Let's see. Enforcement of rights. Let's see. Shall not adverse affects the rights of. Damn. Let me see. Let me. I'm gonna hold on a second. I'm gonna find out exactly what it is. 301. I think it's 301. Let me see. Nebraska 87301. Get your butt out of here. Okay, it was it. This is 1301. It's 300. Let me try 300. Y'all bear with me. Bear with me. Family. Shit. But the thing is saying the same thing. I went to go to my text. I was texting him, so I just texted. I text to him. 301. I sent him that one already. It was showing me exactly what the hell. Not that one. Anyway, I'm just gonna start from scratch. Trade name registration. Is it 301? I said that already. Let's try it like that. Okay. Let's see what they saying. It was 209. 209. A name shall not be registered. It says a trade name shall not be registered if it consists of a comprised of immoral, deceptive, or scandalous. Okay, telling you basically the requirements of what types of names that can be registered or whatever. Consists of a comprised of matter which may disparage, bring into contempt, or disrepute, or falsely suggest a connection with suggest connection with persons living or dead, institutions, institutions, beliefs, or national symbols. I guess in this state is different. They got something set up different in here. Hold on a second. A trade name should not be registered if it consists of or comprises immoral, deceptive, or scandalous matter. Number 2, consists of or comprises matter which may disparage, bring into contempt or dispute, or falsely suggest a connection with. This comma right here, though. Persons living or dead. Institutions, believe. This is this confuses me because it's got that comma right there. Because I want to bring those together and then they sound like a complete sentence. But it said or falsely suggest connections with. And it says comma persons living or dead. Okay, I know you can't trade. You shouldn't be doing nobody's name. Somebody that's dead. You shouldn't be doing that. So it got to be. Well, we already know it got to be a straw man. A straw man is not a dead man. It's not somebody living anyway. But anyway, I don't know if that's supposed to be some type of deception anyway. But anyway, institutions, beliefs, or national symbols consist of, comprises, or simulates the flag or coat of arms or other insignia of the United States, any state or municipality or any foreign nation, consists of or comprises the name, signature, or portrait of any living individual without his or her consent. Okay, now, and this is a semicolon, this is a continuation. So all of this is basically talking about all of this. Now, that's not what I was looking for, though. This is basically talking about the requirements. Let me see if I can go forward. 10. Subject to the limitations set forth, of any person who adopts a trade name for use in this state may file in the office of the Secretary of State. This is what I was looking for. 210. Goddamn. Must file with the Secretary of State in the form furnished by the Secretary of State. An application in duplicate for registration of the trade name, setting forth, but not limited to, the following information: the name, the name and street address. This is just telling you what you got to have on there. This is more like the trade name. What you call it? The registration statement is what I can call it, because when I told y'all, I said L. McHale is the grantor beneficiary of Michael Eugene Roseman, all caps name, estate. I was saying that and it's being conducted, business being conducted at this particular location. The nature of the business is, that's what this is talking about. The type of business, which is the nature of the business. Basically, it has all that written on there that you put on top of the affidavit. The affidavit that you get from the newspaper company, you put this with it. And this needs to be notarized. This is what I did anyway, but you do it according to your state statutes, because according to state statutes, this is what I had to do in Georgia. Okay, but this is what this is saying. You got to have all this done. It then says, upon compliance by the application with the requirements of sections, whatever, the Secretary of State shall return a duplicate copy stamped with the date of the filing. That's a file stamp copy to show you that's been done, to the applicant or the representative submitting the application for filing. The fees, at that point you probably can file it in the county recorder's office. Anyway, that's just something I just said. The fees for filing under this section shall be payable to the Secretary of State. The Secretary of State shall remit all such fees collected to the state treasurer. The state treasurer shall credit 60% of the fees to the general fund, and 40% of the fees to the Secretary of State cash fund. Now, this is what they're telling you what they're going to do. This is how you're going to do this. This is in Nebraska, that is. Okay? My partner, I was just hung up with my partner showing him about this. And I have to make this video because I want to show you what I showed him when it came to this here. Okay? Let's see. And it's basically talking about the renewal, when you got to renew it. Some states require you to renew it after a certain time and how long it lasts, and and the fees for doing it. That's what this is about. Recordation. Let's see. Any trade name registered under section whatever shall be assigned with the goodwill of the business in which the trade name is used. And let me see. Hold on a second. Here we go. Okay, here we go. Now, is used. Assignment shall be by the instrument in writing, duly executed in duplicate, and may be recorded at the Secretary of State upon the payment of a fee of $30 if the filing is submitted in writing, and $25 if the filing is submitted electronically pursuant to section 84-511. The street address, city, and state of the signee must be included in the assignment. Upon recording of the assignment, the Secretary of State shall return a duplicate copy. Anyway, I'm gonna fast forward on this here, but this is basically telling you the instructions on what they have to do in Nebraska. If you're in Nebraska, you already know this is how you find this code. Just type it in your Google search and you'll find this. I'm gonna move forward because I don't want to drag this out. Okay, I'm already 26 minutes in and I'm behind really. Okay, Secretary of State shall keep a public examination of a record of all trade names registered and renewed under this section. Okay, I want to show you the part about about failure to do so. Okay. Don't want to do that. No, that's great. Let's see. Action for misuse and when. Let's see. Subject to this. Whatever. Any person shall be liable to a civil action by the registrant of the trade name for any and all of the other remedies provided in section 87-217 if that person shall use in connection with his or her business without the consent of the registrant any reproduction, counterfeit, copy, or colorable imitation of the trade name registered under section 87-208 and to 87-219.1.01 in manner likely to cause confusion, mistake, or deception of purchasers, or reproduce, counterfeit, copy, or colorably imitate any registered trade name and apply the reproduction, counterfeit, copy, or colorable imitation to labels, signs, prints, packages, wrappers, receptacles, or advertisement intended to be in conjunction with other businesses in this state, except that the registrant shall not be entitled to recover profits or damages unless the act were committed with knowledge that the imitation was intended to be used to cause confusion, mistake, or deception of the purchaser. That's not concerning what we talking about, but that's if you're doing business like y'all know what I'm talking about. But this is, let me see. I'm trying to find a certain part. Injuries to the business, enforcing rights. I read that part already. Here we go. Is this what I was talking about? Publication file failure. Every duplicate shall cancel. No, that's not what I was looking for. I think it was 301 that I was looking for this time. Registration procedure. Protest. No, that's not it. Here we go. Remedy. Here we go. A person likely to be damaged by a deceptive trade practice of another may bring an action and the court may grant an injunction under the principles of equity. Keyword equity against the person committing the deceptive trade practices. If that's not what they're doing when they got you acting as a straw man, they're using legalese to try to bully you into these court cases. Anyway, we're gonna keep moving. The acting under color of law. Okay, keep that in mind. They're acting under color of law. Okay, the court may under such additional equitable relief as it deems necessary to protect the public from further violations, including temporary and permanent injunctive relief. Proof of monetary damage, loss of profits, or intention to deceive is not required. Say relief granted for the copying of an article shall be limited to the preventive of confusion or misunderstanding as to source. Let me see if I go. Let's see. Cost shall be allowed to the prevailing party unless the court otherwise directs. The court in its discretion may award attorney fees to the prevailing party if number one, the party complains of the deceptive trade practice has brought an action which he or she knew to be groundless, or two, the party charges with a deceptive practice was willfully engaged in the trade practice knowing it to be deceptive. Y'all know that's what they're doing with child support, so we ain't got to even go there with that. A claim filed in violation of Uniform Deceptive Trade Practices Act shall be proved by a preponderance of evidence. The relief, of course, you got to prove your claim when you say you bring a claim against somebody. Okay. And see, the relief provided in this section is not addition to remedies otherwise available against the same conduct under the common law or other statutes of this state. Most of y'all be want to see common law, and y'all don't do a registration of trade name. You ain't no common law remedies. Let's see. Subsection A13. Of section 87-301 shall not be construed to authorize a civil action against an interactive computer service provider, telecommunications service, or cable operator for the actions of any information content provider. Now, do I need to read that? I don't need to read that. But anyway, this is pretty much what's just showing you. This actually what gives you. Let me see, unconscionable act. Oh, that word caught my attention. An unconscionable act or practice by a supplier in connection with a consumer transaction shall be a violation of the Uniform Deceptive Trade Practices Act. The unconscionability of an act or a practice shall be a question of law for the court. Yeah, y'all remember we used to talk about unconscionable contracts? We hadn't seen that in a minute in a lot of these doggone state statutes. Unconscionability. They realize it's a one-sided, in case y'all don't know, one unconscionable contract. We'll look that up in a second, and I'm gonna close with that. If it is claimed to appear to the court that an act or practice may be unconscionable, the parties shall be given a reasonable opportunity to present evidence as to its setting, purpose, and effect to aid the court to making its determination. See, people, remember we used to talk about we used to use that as a defense of being an unconscionable contract. But if you try to bring that as your defense and the name is not even registered, you still don't have no standing till you do that. So I'm gonna look up unconscionable. Unconscionable. Y'all know I like my certain websites. Unconscionability. The defense against. I want to look at not the word unconscionability, but I want to look at the word unconscionable. I liked it. I was looking for this damn website. They done changed the icons or something on it. It used to be okay. Anyway, unconscionable contract is a contract that is so severely one-sided and unfair to one of the parties that it deems to be that it is deemed unenforceable under the law. Unconscionability is the contract. Unconscionability in contract law means that the contract is one that leaves one of the parties with no real meaningful choice, typically due to the significant differences in bargaining power between the parties to the contract. One of the main characteristics of unconscionable contracts is that one of the parties signed the contract in a situation that involved pressure, lack of information, or because they were misled. Y'all know that's how y'all get in them damn child support contracts. Y'all don't even know the damn law, but y'all got bullied. Y'all got lack of information. If you got an attorney, they don't never work for your best interest. They always tell you that this the only way to do it is to agree to every other weekend. That bullshit. Nobody wants to be no half at no 4 days out of a whole month helping raise a child. You can't even raise your kids with 4 days out of a month. Let's see, signing of a contract. Let's see, parties sign the contract in a situation that involved pressure. When the judge is bullying you, they go to talking to you like you're a damn kid, like you got no damn say so, and you feel intimidated because they go to court threatening you with contempt if you don't comply with what they want you to do. I got threatened too. They tried that shit with me too, but I called their bluff with it. So anyway, but they, especially you see that guard standing there with the damn gun, really looking like they're ready to jump. Time you say time, they say don't. No. Anyway, and they were misled. There's all types of misleading up in there, especially when they're using legalese. They're using different language. They don't use plain English in their wordings. They don't use plain English in not even on paper, not even in open court in their hearings. It's an unconscionable. It always leads to an unconscionable contract. If a lawsuit is filed and the court if a lawsuit is filed and the court finds that the contract is unconscionable, the contract will typically be declared void. If the contract is declared void, there is no damage. There is no damages awarded or specific performance ordered, but instead the party will be released from their original contract obligations. An unconscionable contract is also a type of abuse of abusive contract. Y'all know child support is goddamn abusive. Y'all know it. Abusive contracts are illegal and unfair, and no one of the part, and it says is unfair to one of the parties. These type of contracts are void under the law and are not enforceable. The thing is, the reason I use the word contract is because they have to have your agreement, and baby mama and baby mama and baby daddy have to agree some type of way, whether it's by ignorance, signing something, fear. That's not the right way. That's not the proper way to do a contract, because if a contract is void if either one of those, if deception is used, intimidation is used, there's not a meeting of the minds of being done in a contract. They bully you some type of way by getting you to, they use deceptive acts because they know you don't know that you're not the straw. They don't know that you're acting as a straw man. They don't know that there are presumptions in the court that you don't know nothing about. They know this and they're trained to know this, and you don't know. You don't understand the language of the court. You end up in an unconscionable agreement. So they end up making an order enforcing something that you agreed on, not knowing. That's basically what a court, they basically do an order based on what y'all agreed on. So they basically trying to enforce some type of contractual agreement. That's basically all they're doing. So they making it like you agreed to that shit some type of way, and they're making it like that's what makes it law. They try to enforce it as if it's law because of the fact that because your fear and your ignorance of contract law. Anyway, I'm ranting now. So I done got into 40 minutes. I wasn't trying to do this. I'm gonna read this last part and I'm gonna get out of here. An unconscionable abusive contract is a contract that is so one-sided it would be unjust for one of the parties to be required to perform their duties under the contract. The majority of abusive contracts are deemed unconscionable due to unequal bargaining power between the parties due to one party's lack of knowledge, experience, or resources. Think about it. When somebody say they want you to keep in mind, you created your babies. You and baby mama, y'all both created your baby. I'm talking to the men. Okay, so I ain't trying to trigger no women, but goddamn it, y'all know what the general behavior is in family law. So suck it up and work with me on this. Baby mama and baby daddy create the babies. The baby is the baby is an equal creation between both parties. Both of them, without both of them participating in consensual sex, the baby would not exist. There's no way in the hell you should tell me I gotta fight for my rights to help have equal say so and having to raise my baby. I gotta jump through all these hoops with learning the law, learning all this different stuff, and she don't have to know shit. All she comes in there, all she gotta do is hire an attorney or a social worker, and they do all the work for them. And they can walk in there ignorant as hell with a smile on their face, and you can get your ass handed to you simply because you don't know the law. And that's one-sided. And then they're speaking a language you don't know nothing about. Everything is against the father most of the time. And then when you don't know the law, you don't have the courage to fight, or you don't know how to fight because you're scared if you do fight, you just might get thrown in jail if you even try to buck. That fear kicks in, and then you find yourself in the situations that unconscionable abusive contracts. That's what you end up with. And that's what in the form of an order, quote unquote. That's how they end up getting these things. And when you register that name, you do a trade name registration. I would do a petition for a writ of habeas corpus. Go back and look at my previous videos about petition for a writ of habeas corpus, and you use that certified copy of your trade name registration. I would even get a certified copy of the state constitution and filed in there. And you type up your petition and try and get your remedy, because they got at that point you operate in equity at that point. Remember my point? I highlighted in that thing about equity, where it says getting your redress in equity. Where is it? Go back. There we go. Equity, equitable relief. You get that's what governs a petition for a writ of habeas corpus is the equity courts. You're gonna operate in equity when you're doing a petition for a writ of habeas corpus. A habeas corpus is also constitutional. They can't buck you on that. So you got the certified copy of that state constitution. You don't need nothing but the Bill of Rights in there. That's just the one part of it. You don't even need the whole constitution. Get the state constitution or the Constitution of the United States of America. You can get that, because that you can use that in any of the 50 states, because every public official took an oath to both of them, the one of their state and the one of the United States. So you can get a certified copy of either or in your state, and then you file that with your standing, your standing right here, your registration, and you have that with your petition, all that filed together, and you get there and go through the process of how you're supposed to do it in your state, a petition for a writ of habeas corpus, and you run with that thing and see how you're gonna come out with that. Anyway, I'm getting out of here because I'm past 40 minutes. I wasn't even trying to be this damn long. That's why I'm talking fast, because I was trying to make it fast. But I'm gonna get on up out of here, y'all. I hope this helped y'all out. But look in your state statutes and see exactly what it says about your state statutes and concerning a trade name registration, a DBA. Some states call it a DBA. Some of them call it a trade name registration. Some of them call it a fictitious name, and some of them call them assumed names. So look in your state statutes and do the shit properly. Don't do it like Stevion had when they had them folk doing. I ain't gonna get on Stevion. I'm out of here. Rose signing out. Get on out of here. Hey, don't forget to y'all like and subscribe, y'all. Don't forget to like and subscribe if you haven't done it already. But anyway, I'll see y'all in the next video. Rose signing out.